Good afternoon. Hi. So it's the first time I'm doing this Express segment, and at the very least, I hope I will entertain you. So I don't profess to know that killer argument that's going to convince the court one way or the other. Neither do I have some playbook that's going to help you get around all the legal issues. So what I will do is just a quick scan of some of the cases in copyright and generative AI, and give you some food for thought on how generative AI might develop and how we might adapt to the challenges. So in my day job, I work at Changi Airport, and we operate the airport in Singapore. Just, about 22 hours of flying to get here. So sometimes I dream of being an artist. So today I'm going to get all of you to join me in my little artist adventure. So I want you to imagine with me, and you can close your eyes if you want to. Imagine a blue elephant on an airport runway. Now, let's make the sky rainbow-colored. Maybe I want to put a fridge on the runway. And then let's make the elephant fly. Got that picture in your mind? So let's see what I got when I put these prompts into Gen AI. A blue elephant on the runway. A rainbow-colored sky. A fridge on the runway. And now my favorite, let's make the elephant fly. So I'm going to guess that none of you had the same image in your mind as what you see on the screens. Well, it certainly wasn't what I thought when I thought of these prompts. So I'm just going to show you what I drew. So I think I probably should stick to my day job. But let's just say that I really liked some of these Gen AI created images. And maybe I want to print them on t-shirts for sale. Then I probably want to make sure that I own the copyright in them. But that's where my trouble begins. Because really, depending on where I am in the world, most jurisdictions seem to have said, no copyright protection. But if you think about your favorite books, movies, songs, copyright ensures that the creator's expression is protected so that they can benefit from their creativity. But in the last 18 months, Gen AI has tested, stretched, and challenged our understanding of what human creativity and expression means. So I'm going to do a quick look at some of the jurisdictions and how they've approached this question. So in the US, the position is fairly somewhat clear, that you don't get copyright protection for Gen AI created works. So famously, in the case of Naruto and Slater, the Court of Appeal of the Ninth Circuit held that a monkey who took a selfie couldn't own copyright. Well, this is, of course, long before Gen AI exploded onto the scene. But it set the foundations for how the courts would approach this question. Now, there are many cases that are ongoing at the moment, and it's impossible for me to go through all of them. So I'm just going to zoom in to the case last year from Zara of the Dawn, where the US Copyright Board held that the creator who used Midjourneys put in hundreds of prompts to generate some of the illustrations you see, who then put that pictures together with her written text into a comic book. Well, the Copyright Board said that the images were not protectable by copyright, but it granted copyright for the text and the arrangement and selections that form the comic book. So it seemed that where a work is perhaps partly created by Gen AI, that you could get some copyright protection, but only insofar as it pertains to the human-authored aspects. Now let's take a look at how Europe's dealing with it. So in the EU and the UK, and in the EU, the regulations are really a patchwork of directives and regulations, but importantly, none of it, including the new EU AI Act, specifically addresses the question of copyright ownership for Gen AI works. It is possible if you can show that there is originality flowing from the author's creative expression or or intellectual creation. But how much human authorship is required to pass that threshold isn't quite clear. Now, in the UK, they even have a class of works called computer-generated works. And it goes further to say that the owner of these works is the person by whom the arrangements necessary for the creation of the works were undertaken. Now, who that person is also not so clear. But whatever the position is, that position has been ratified recently after a consultation. Now, let's take a look at how China's approaching this. And this is interesting because this picture was granted copyright, and this picture was created with Stable Diffusion. So, late last year, the Beijing Internet Court held that this picture had met the twin requirements of originality and intellectual achievement. And this was because the court said that the creator's text prompt inputs into the platform and the setting parameters had resulted in a personalized expression. And the court went further to say that the owner wouldn't be the developer of the platform. That's because the developer didn't have the intention, nor did it provide the text inputs that generated this image. So these cases really sort of raise a lot more questions than I think they do answer. But I'll just offer an observation. So I think in all the cases, the principles of copyright actually don't differ very much, to the extent that in the cases of Li and Liu and Zarya of the Dawn, the arguments raised by counsels were actually very similar, even if they had different outcomes. So what did it ultimately boil down to? It seemed, on a closer read of the cases, that really it's about what the court understood the technology and how it works. So where a court thinks that the creator's input into the platform and the output of the Gen AI, that causal link is broken, such that the outputs can no longer truly be said to be the creation or the expression of the creator, then no copyright subsists. So I'm going to tell you a little story to illustrate what I think about Gen AI. So I have a 2-year-old nephew. That's him. And he's at the stage where he's constantly going, "What's that? What's that? What's that?" So the other day, I was with him at my friend's house, and I was carrying him in front of a shelf full of toys and figurines. And he was going at it, asking me, "What's that?" And my mind was slightly distracted. I was thinking about what I would say at this talk. And so when he asked me, "What's that?" I said, "Figurine, figurine, figurine." But then he stopped me. And he said, "No, uncle, mouse." And that got me thinking, what if Gen AI was very much like a child today? Sometimes it surprises you beyond what you think or thought it could deliver. Sometimes it gives you far more than you expected. Yet sometimes, try as you might, even if you give it many prompts, it just won't give you what you're envisaging in your mind. But what if AI could grow up? What if it could get that knowledge over time, gain such ability to comprehend, so that one day it could deliver what you had in your mind and give you exactly as you instructed, exactly as you had envisaged? If you think back, we used to have scribes who would write or copy what we dictate. And in modern day, we use all sorts of tools, like spell check, like video editors, photo illustrators. And I think everybody here would agree that the tools don't become the copyright owner. We're still very much in charge. So if Gen AI becomes able to deliver exactly as we express, exactly as we tell it, doesn't it not, and shouldn't it not then be a tool? And so then the causal link between my inputs to the Gen AI model and the output is unbroken. So let's go back to my experiment at the start. I don't think that Gen AI today is at the stage where it's my scribe or a tool that could deliver what I thought. So what does this all mean for us as in-house counsels? Because we have to grapple with the fact that maybe you're not going to get copyright protection. So I have 5 points, or 5 takeaways. I think the first is pretty obvious. You got to know where you're creating your works, right? Your jurisdiction matters because clearly some places are more likely to give you protection than others. A second is, can we use Gen AI in an assistive way rather than replacing our creative processes? So maybe creating an element that goes into a larger piece of work. Thirdly, I think it's important for us to keep records. Records of what platform you're using, the text inputs that you've given it, the setting parameters, because if challenged, you're going to have to show that unbroken link between your inputs and the output. And fourth, I think all of us, and any external counsels we use, have to have an understanding of the technology. Because how you frame and how you explain to the court the technology is going to make a difference in the outcome. And lastly, if copyright was granted, you want to make sure that the platforms that you signed up with, the services that were responsible, those terms and conditions have given you the necessary assignments or the clauses are sufficient so that it doesn't become an issue at that point. So my 2-year-old nephew is going to grow up, and I am constantly amazed at how much he learns from just observing the world. Much like how I think Gen AI is going to also grow, and it's going to gain knowledge and gain comprehension. But I'm not going to wait until it reaches that maturity before I start using it. Instead, I think I'm going to acknowledge its limitations, acknowledge the legal challenges in this area, as Gen AI becomes a collaborative partner so that it can assist me to better use my creative spark. Thank you.